Yes, Mr. Byrne.
Thank you, my lord. Just a few points on pool as seen through the eyes of HXA, still on assumption of responsibility. Simple point being made in this case here is that, or in pool, is that the statutory functions relied on in the pleading did not entail that the council had assumed or undertaken responsibility to perform any function with reasonable care. And then you see that if you turn to paragraph 55D to E, core authorities 482.
482?
Yeah.
Thank you.
And you see there a section that begins, and paper begins at 479. 53, Lord Reed rejected a submission that a public authority cannot assume responsibility merely by operating a statutory scheme, etc. 54, Lord Reed proceeded to apply those principles to the pleaded case. Then he found that B, reliance not necessary. It may have been reasonably foreseeable that their mother would have been anxious, that the council should act so as to protect the family from neighbours, in particular by rehousing. Anxiety doesn't equal reliance.
I'm very sorry, I'm behind you, Mr. Byrne. What page are you on?
Sorry, that's page 480 paper, so that'll be 482, paragraph 54 of HXA. So you see that?
Thank you.
In pool, the claimants couldn't say they'd entrusted their safety to the council, and there was a pleading problem. We certainly absolutely don't have that in this case. In this case, it's quite clear that we say her safety, to the extent of the narrow duty sought, was entrusted to the police. The council were found not to have accepted responsibility in both those cases, in pool and HXA. But plainly for the reasons I've gone over, and Mr. Justice Ritchie stated clearly in his judgment, everything leading up to the attack, the course of dealings, puts this case outside the type of failure to remove case that Mr. Warnock was taking you to. Also on reliance, I won't turn it up, but could I referred to White and Jones. I mean, those are important sections. It would take too long to go through them. But could I give you another reference? Supplemental bundle of authorities, 1523. That's Nolan, a academic who's written a lot about this area. Nolan on reliance, 1523. And one of the points he makes is that no reference was made in Michael to White and Jones. I think that's where he described White and Jones as about the most illuminating case there has actually been on assumption of responsibility. Yeah.
Obviously, it's rather slow in taking up. You're in the supplementary bundle. Page what?
Supplemental bundle, yeah, 1523. I mean, I wasn't going to turn it up, but I'm just conscious of the time. Let me just have a quick look.
This is Donald Nolan's.
Yeah.
Okay.
Yeah, it's the passages, I think, are sidelined by the look of things. Yeah, the sideline passages at 1523 to 1525. So I'd ask you to look at that in due course. Then we get to Darnley. Darnley was a case, I mean, you'll be acquainted with the facts. That's the receptionist in the Accident and Emergency Department giving misleading information to somebody who comes in with a head injury. Relying on that information, leaves, goes home, collapses at home. Had he collapsed at the hospital, but for the inaccurate information, he wouldn't have suffered the brain damage. Standard of care.
Are you going to give us the reference that you're referring to?
Yeah. I'm sorry. I'm sorry. Core 275.
Core authorities.
Core authorities. Yeah. And that's paragraph 19. The relevant paragraphs are 19 to 20, where you see the finding of assumption of responsibility. And then also, if you have a look at what Lord Lloyd Jones says in relation to incrementalism, and really applying the test that's set out by Lord Toulson initially and Michael, or reflecting the law as it's been for a long time. At paragraph 102, which you see at core, I think it's at 146, I think. Yeah, 146. It's a passage which I think Mr. Warnock may have taken you to.
I am really sorry, Mr. But you're. I'm trying to take a note on the basis you want me to read it later. I'm trying to take a note now, but I'm trying to see that I've got the thing right.
Yeah.
Darnley, you've given us page 275 of the bundle, paragraphs 19 to 20. Is that correct?
Yes, that's right. That's right.
And you rely on that for what?
I rely on that to show that there was an assumption of responsibility in that case, really quite similar in terms of the misleading information that was given to the neighbour in relation to the conversation about the neighbour.
What was the misleading information?
The misleading information in relation to the neighbour was giving the impression that there was going to be enough done for her to justify standing back. So it goes to the making matters worse.
So giving an impression is misleading information.
Yes, sufficient in this case. Yeah, absolutely. And then I then rely on, in relation, if it's said that this is effectively been treated as a novel case, then you need to look at paragraph 15 of Darnley. And that is and I haven't got time to read all these sections out to you, my lords. But there's useful guidance there on when you recognise a novel case.
So which paragraph?
Paragraph 15, 275 on the screen in Darnley. And that is relevant to the arguments on control, which would be novel in the sense that no case has yet been fitted or has fitted into the control, the Tafaris 3 control exception, recognised, of course, by Lord Toulson in Michael, and that would enable the consideration of policy considerations, and those policy considerations are in the judgment and were read to you yesterday by Mr. Warnock. So that's what I say about Darnley. Could I just give you a Clark and Linsell reference in support? Supplementary authorities 1365 to 1366. And that's paragraph 761 to 763. In relation then, now I'm moving on to Robinson. And if I could just give you this morning, I was referring to how there's constant reference to special circumstances such as an assumption of responsibility. Could I just give you the references for those? Paragraph 38. Core 185, and these are just examples. Paragraph 50, Core 189. 189, 187 paper. Paragraph 62 and again 63, Core 192. Paragraph 64, quoting Van Colley and Smith, the court talking about the rule biting absent special circumstances such as assumption of responsibility. Core authorities 193, the precise reference 757 C to D. The reference in Robinson which I used to talk about when I was talking about the making matters worse argument. And once you have created or increased the danger, then having a duty to mitigate, and that is then the negligence, is 69.4, and also I think at paragraph 70, and that is core 195. Uh, 195 is the reference to 1694, and then 70 is 196, letter G. Returning then to the second of the issues identified in paragraph 20 above, it follows that there is no general rule that the police are not under any duty of care when discharging their function of preventing and investigating crime. They generally owe a duty of care, so generally, when such a duty arises under the ordinary principles of the law of negligence and as statute and the common law provide otherwise. Applying those principles, they may be under a duty of care to protect an individual from a danger of injury which they have themselves created, including a danger of injury resulting from human agency, Dorset Yacht, and the Hartwell case. And that's then what creates the duty then to act, to meet the danger, or the additional danger, the fact that matters have been made worse, and that is simply here the giving of the warning. So a point I think I've made already, these references and the way that the judge, or the learned Lord Reed, the way he expressed himself, gives more than enough space for you to then read in, if I need it, the submissions I've already made on exceptionality. And on exceptionality, could I just give you the precise references to where you find, if I can now find them, the references to Brooks and Smith. The exact references in the bundle are, they're collected by the judge at Woodcock core 64 to 67, paragraphs 33 to 41 of the judgment, but not in their entirety. The list in relation to the law reports themselves are Lord Nichols, paragraph 6, core authorities, page 6.
Page what?
Page 6, paragraph 6, coincidentally, page 6 of the bundle. Lord Stain.
I'm terribly sorry, I still didn't hear the page number.
Oh, page 6.
66.
No, 6. Page 6 of the core authorities bundle.
Thank you.
What paragraph?
Paragraph, a lot of sixes, paragraph 6. I'll just get it up. Let's read that to you. 6. Like Lord Bingham and Lord Stain, in reaching this conclusion, I'm not to be taken as endorsing the full width of the observations in Hill. There may be exceptional cases where the circumstances compel the conclusion that the absence of a remedy sounding in damages would be an affront to the principles which underlie the common law. Then the decision in Hill's case should not stand in the way of granting an appropriate remedy. That's Brooks, and then Lord Stain at page 19 of the bundle. It is unnecessary, paragraph 34, letter D to E. It is unnecessary in this case to try to imagine cases of outrageous negligence by the police unprotected by specific torts, which could fall beyond the reach of the principle in Hill's case. It would be unwise to try to predict accurately what unusual cases could conceivably arise. I certainly do not say that they could not arise, but such exceptional cases on the margins of the principle in Hill will have to be considered and determined if and when they occur. And then Lord Phillips, at page 73 of the core authorities bundle. And he says, it's having quoted Lord Steyn at 34, the passage I just read, it's unnecessary in this case to try to imagine cases.
Which paragraph?
Sorry, 96.
So we've moved to Van Col here, have we?
No, we're still in Brooks.
No, we're not.
No, we're not Van Col.
Sorry, hang on. Oh, sorry, we're Van Col and Smith. Forgive me. Unnecessary in this case to try and imagine cases of outrageous negligence, unprotected by specific torts, which could fall beyond the reach of the principle in Hill. It would be unwise to try to predict accurately what unusual cases could conceivably arise. I certainly do not say that they could not arise, but such exceptional cases on the margins will have to be considered and determined
Isn't that
if
the
and when they
paragraph
occur.
you just read to us?
Yes.
James Brooks, paragraph
Well, this is
34 on page 19.
Yeah.
The last thing you gave us.
Yeah. I'm sorry.
It's the last reference you gave us.
I'm sorry. Well, and you see there Lord Phillips agreeing, and then Lord Hope at 69.
Sorry, where does he agree specifically?
Sorry.
Paragraph 98, Lord Phillips says it's not an easy question.
Yeah.
Just looking to see where he explicitly associates himself with what Lord Steyn had said.
Yeah, I'll have to come. Forgive me. I'll have to come back and check that. But then Lord Hope.
Well, might it be 101, Mr. Byrne, where Lord Phillips says he doesn't agree with Lord Bingham's liability principle. He thinks that the facts in the instant case comes close to constituting the outrageous negligence Lord Steyn contemplated, being potentially outside the reach of the principle. But he hadn't found any principle basis for putting the case outside the principle. So to that extent, that's the agreement, is it?
Yeah, and then Lord Hope at core 69, para 78. As in the case of the Osmond test, the test for the judge must be an objective one. How then is the police officer to deal with the evidence which for one reason or another he or she doesn't find convincing? But what about the risk that after the event a judge might take a different view? I mean, this is a discussion about the liability principle. Take it to G. Lord Nichols of Birkenhead said in paragraph 6 that there might be exceptional cases where the circumstances compel the conclusion that the absence of remedy, standing in damages would be an affront to the principles that underlie the common law. I respect his approach, which is to guard against the dangers of never saying never. But in my opinion, the present case does not fall into that category. That is why if a civil remedy is to be provided, there needs to be a more fundamental departure from the core principle. I would resist this in the interest of the wider community. And then Lord Brown at 135, paragraph 135, Core Authorities 81. True it is that in Brooks, both Lord Nichols of Birkenhead and Lord Steyn contemplated the possibility of exceptional cases on the margin, which might compel a different result. If, say, the police were clearly to have assumed specific responsibility for a threatened person's safety. If, for example, they had assured him that he should leave the matter entirely to them, so could cease employing bodyguards or taking other protective measures himself, then one might readily find a duty of care to arise. That, however, is plainly not the case on the facts of that case. There is nothing exceptional here, unless it be said that this case appears exceptionally meritorious on its own particular facts. Plainly, that's not in itself a sufficient basis upon which to exclude a whole class of cases from the Hill principle. That said, the apparent strength of this case might well have brought it within the Osman principle, so as to make a Human Rights Act claim here irresistible. And then Lord Bingham dissented, and he said that there should be liability. So the commentary, as I understand it, in relation to those passages, is that it was accepted that this exceptional category had been acknowledged, albeit a case had yet to come along where the category had been used, and that's of course what Mr. Justice Ritchie was doing, and then quoting the authorities, which I won't go through, possibly to take you to Rush, where he says, "I find helpful the examples that he then gives." There's Dytham, where Dytham in Hill, it seems to be accepted that there would be a common law remedy.
Why do you say that?
I'll give you that reference in a moment. But let me, as I'm in Van Col, I think there's a similar reference from Lord Brown.
Oh. 76.
What, paragraph 76?
No, page 76. The hard copy.
No, it's not page 76. Oh, I'm sorry.
You're looking for the reference to exceptional circumstances.
Yeah, I'm just having. Yeah, it's paragraph 120, so page 78 of the bundle of Van Col and Smith. And this is Lord Brown commenting on Dytham.
Page 170? No, page 78.
Page 78 of the core authorities, paragraph 120. So he's discussed there at paragraph 20, there are such cases that in what circumstances ought the police be subject to liability, and then he goes over Swinney, Costello, and then refers to the case that Mr. Justice Ritchie referred to, Dytham or Dytham. That's the watching somebody being murdered outside a nightclub and not intervening, referred to by Lord Bingham at 53. Would nowadays have a common law claim against the police. So I will take the whole sentence, sorry. The inspector was present specifically to help the claimant if she needed it. And himself acknowledged that he had a duty to do so. Yet he stood by and did nothing when in fact she was attacked. Now that's a reference to Costello. By the same token, it may well be, accepted as may, it may well be that the family of the victim whose death underlay the criminal conviction in Queen and Dytham, referred to by Lord Bingham at 53, would nowadays have a common law claim against the police. The constable in that case was, after all, convicted not merely of non-feasance, but of deliberate failure and willful neglect. So those are the references.
Could you help me? I've got the reference to Van Col. I thought you said that Hill accepted that there would be a civil remedy in the case.
Yeah. Well, let me just show you exactly what was said by Lord Keith. Hill, you find starting at 93 of the supplemental bundle. See at page 99, letter D. My computer is still searching for it. And this is the section that starts at C that Lord Reed, of course, referred to in Robinson. There's no question that a police officer, like anyone else, may be liable in tort to a person who's injured, etc. May be liable for assault, unlawful arrest, wrongful imprisonment, malicious prosecution, and also in negligence. Instances where liability for negligence has been established, Knightley, Rigby. Further, a police officer may be guilty of a criminal offence if he willfully fails to perform a duty which he is bound to perform by common law or by statute, where a constable was convicted of willful neglect because of the presence at the scene of a violent assault resulting in the death of the victim, and he had taken no steps to intervene. So that is quoted in the same context.
But that's not talking about a duty of care.
Well, he's talking about a bound to perform an obligation by common law. I mean, I accept. I mean, it's not as strong as what Lord Brown was saying. So, if I then take you to Selwood, which you see at referred to in my skeleton at paragraph 49 for your note, supplementary bundle 615. And there, 617, you'll see in the head note. It was arguable that the position of the NHS was analogous to the position of the police, who may be under an operational duty to warn a person who they know is at real and immediate risk of being killed by a person with whom they have been involved. And then I commend to you the whole of this judgment, which obviously I won't have time to look at in any detail, but she addressed Mitchell at paragraph 23, and the reference that we've seen to Mitchell at paragraphs 28 and 29, where no duty to warn generally on the housing authority. The Strathclyde Police were the relevant public authority for that type of protective action, but Lord Hope in Mitchell saying it might be different if there was an assumption of responsibility. So applying that to the facts of our case, once we have got that assumption, or I've got a route to liability under one of my other routes, then we are within Lord Hope's contemplation of a duty to warn. That duty to warn being much narrower than a full duty to protect. And the notion of a duty to warn being if you can't actively protect or control the risk, what can you do? You can only convey the information. As I think I've made clear, we accept, that prior to the 18th of March, the police here only had a public law duty to protect on the facts. There was no private law duty via an assumption for Mrs. Woodcock's safety, which crystallised at the very latest, when they were given information by the neighbour. Course of dealing, a point I've made repeatedly. Acute increase in risk, promised they'd sort him, etc. I've gone through the facts. Now, there wasn't in Selwood enough to establish an assumption of responsibility in that sense. So what the court did was to infer from working arrangements and protocols and policy that there was an assumption, and that's where they refer to the Silver case. And you see that at paragraph 52 of the supplementary bundle, page 630.
Who's giving this judgment?
I'm sorry?
Who is giving this judgment?
Lady Justice Smith.
Thank you.
And paragraph 50, the discussion on the common law starts at paragraph 49 at 629. And there's a very informative hypothetical that's set out at paragraph 47, which is directly relevant to the duty to warn. And I mean, it's quite, the facts are quite complicated, but the answer, I mean, I can just very quickly go over them. There's a cooperation agreement. So you imagine this was discussed in argument. There are two police forces, a bit like Michael, neighbouring police forces. Force A receives an emergency call that there's a hostage taking, and they send officers, but there's a cooperation agreement. And Force B also send officers. On this occasion, Force A receives information that the hostage taker has a gun, but Force A do not pass that information on. The two officers are talking to the hostage taker. They wouldn't have been doing that had they had the information. The man produces the gun, you see this just towards the end of para 47, shoots and kills the officer from Force A, the force who had the information but failed to convey it. Mr. Moon accepted that the Chief Constable of Force A would be liable for the death, but he submitted if the hostage taker had shot the officer from Force B, the Chief Constable of Force A would not have been liable. The officer was not his employee, and the Chief Constable of A had no responsibility for him. The general rule as set out in Van Collins-Smith would apply. When it was suggested to him that that did not seem fair or just, he said that the law sometimes had to draw clear lines, and this would be such an occasion. When Mr. Kent was asked about this scenario, he submitted that there would be very strong grounds for arguing that the threefold test would be satisfied, and that the Chief Constable of Force A had a duty of care to the officer from Force B. Common sense and justice demanded such a conclusion. Now that's quite interesting, because common sense and justice, whether you look at it in terms of paragraph 6 of Brooks and the exceptionality route, or in some other route, it just shows here that there are some cases which absolutely scream out for a remedy, and the failure to convey the information provided by the neighbour in this case is just a very similar case, and however one gets there, and this is plainly what was driving the judge, he was going to find a route to do it, and he did it. And yes, in terms of the failure in the judgment to set out completely the Tavares exceptions, and maybe to sort of modulate his argument without going quite so far into exceptionality, I can see criticisms there. But the core of it is sound, and that case, in making that point, that case is useful. On duty of care, you see the court's conclusions 49 to 56, paragraph 49 to 56. The extra something that was called for is she identified control. Well, I haven't taken you to the facts, but it's about control. There was a psychiatrist or a failure to pass on information that an aggrieved party in care proceedings was threatening to kill or harm a social worker if he got the chance. And there's a meeting, and exactly that happens. The social worker is attacked, and that's then. So this is Selwood is a failure to warn case. They had control of the information. They also created a danger in Dorset yacht terms. Mitchell gives us a route through, a point I've already made, divisible from the wider duty to protect. And the inference in terms of the protocols, you see that at paragraph 52.
Still in Selwood?
In Selwood, yeah. 630 paper, 632 screen. However, that's not the end of the question on assumption of responsibility. Having talked about 29 of Mitchell, Mr. Kent submitted that the judge was wrong to reject AOR on the facts. I accept his submission on this point. It seems to me that the judge thought before there could be an assumption, something positive to that effect had to have been said, or at least something done which clearly indicated such an assumption. In my judgment, it's possible to infer it, and then she refers to Silver. And then at the bottom of 53, factors relating to foreseeability and harm and proximity also impinge on fair justice and reasonableness. Indeed, in a case which doesn't involve a public authority, and they quote Everett, where a company was operating a nightclub, there may be a very few additional factors to take into account, where, however, the defendant is a public authority, there certainly will be important additional factors of public policy which must be considered. And that has resonance with the equality principle submissions that I was making this morning. As Mr. Kent accepted, those public policy considerations will often be determinative. In Van Collins-Smith, it was said that in the absence of special circumstances, my emphasis, the police would not owe a duty to an individual member of the public to protect him, or from harm from a criminal for policy reasons. Even there, it was recognised that there might be special circumstances which negated the general rule. I mean, that's a reference to the sections that I took you to. So it seems to me that there will be some classes of claimant who stand in such a special relationship with the defendant public authority that it would be fair, just and reasonable to impose a duty. It's common ground that a defendant will owe the employer's duty of care to its employees, notwithstanding there might be potential conflict. One can see that if a duty is owed to a limited class of employees for actions of a third party, the force of some of the policy considerations which render a wider duty undesirable is much less if the duty is said to be owed to the, or than if it's owed to the world at large. We are here a duty to a single victim, so there is no ripple effect in the way that the duty was found by Mr. Justice Ritchie. Then the same point, and then again read in paragraph 54. And then on the hypothetical, she decides that it's more than arguable that the Chief Constable of Force A would owe a duty to Force B for, provided for his assistance because of the failure to warn. That's Selwood. In terms of the domestic abuse policies and inference, could I just give you the references? Supplementary Bundle 39, definition of high-risk cases, duty to take positive action, Supplementary Bundle, page 42, domestic abuse, stalking and harassment policy, Supplementary Bundle, page 106.
Okay, sorry, page, duty to take positive action, Supplementary Bundle 42, what's the next?
106.
Yes, but what is it?
It's the abuse, stalking and harassment policy. Duty to keep the defendant informed, page 163. Then just quickly on Sherratt, that's 759 of the supplementary bundle, so presumably 761 on the screen. And there, the relevant paragraphs. But I think you were taken to this, you've been taken to the head note by my learned friend. Paragraph 41. Police officers were going to be dispatched to the deceased's house, that they were going to be dispatched promptly and quickly, that she should leave it to the police, including any calling of an ambulance. And I've been through the facts, and I say the comparison runs between the finding here and a finding in our case. So this, if we are looking at incremental or something, has the law, I think in language of paragraph 102 of Lord Toulson and Michael, has the law been here before? Is this terrain the law has visited? And it certainly seems to be so visited in Sherat. Assumption of responsibility, the section starts at page 57. And again, there a quote from 135 of Lord Brown that we looked at. Same quote set out. Lord Steyn as well at a little lower down. Paragraph. This is page 777 on the screen. In such cases, there's no need to embark on an inquiry whether it's fair, just and reasonable for economic loss. Williams and Natural Life. And then, and I think it was Jeremy Johnson, KC, now Mr. Justice Johnson, was in that case. And you will see that he conceded that absent a special feature, such as assumption of responsibility, that it was possible to get into the exception. Then Mitchell we've seen. Just in relation to Mitchell, applying paragraph 48 of Tyndall, no positive action was needed. It's therefore enough that holding the meeting makes matters worse than had they not had the meeting, because he wouldn't have been inflamed. Drummond would not have been inflamed, and that the negligence was a failure to warn. So that's a creation of a danger case.
I'm sorry, applying paragraph 48 of Tyndall.
Yes. That which is the test in relation to page 511 of the core. So if you apply the Tyndall approach to Mitchell, you see there that there is then a route to liability through making matters worse.
Are you applying paragraph 48 of Tyndall in the Supreme Court?
Yeah.
On this appeal, counsel for the claimant have argued that in rejecting the claimant's case. I'm just not quite sure of the link.
Well, I think I've dealt with this point already. It's the.
Well, it's maybe my fault, but I don't understand it.
Probably not. Paragraph 49.
49?
Yeah, maybe it's 49, sorry. The exception relied on, this is preventing another. I've already looked at this, so I'd very like to spend more time on it, but Tafaris and Steele themselves recognise this when they return to the category of case later in their article, analysing when a duty of care is owed by the police. In that context, they describe the category as one where the police involvement prevents alternative means of rescue, thus making the matter worse. This is not to deny that this particular form of making be worse off merits particular attention when one is looking at liability for omissions.
So are you submitting that Mitchell should be interpreted as a case of making matters worse?
I'm saying, yeah, in relation to, if I'm right about the, sorry, I'm having some trouble with the machine here.
You have my sympathy.
You're not.
I too have some difficulties, though not nearly as bad as yours.
I need your auditory expertise. In relation to the neighbour issue,
And we're talking about Mitchell.
Well, we're talking about Mitchell as an example where by having the meeting, if they hadn't had the meeting, so the counterfactual is they don't have the meeting. They don't have the meeting, they do nothing. And what would have happened if they'd done nothing? Drummond would not have been inflamed, he wouldn't have gone around, he wouldn't have beaten up his next door neighbour and killed him. A bit like the argument about in Tyndall, where my lord was against me on the basis that I was saying, and that was accepted by the Supreme Court, that simply by turning up, that was enough to make matters worse, because Kendall would have assumed, this is, I think, this is the reference, I think, to where they say you came close to making the right point, but went wrong because you then demanded positive action. The police had done nothing themselves to, it's the section where they say, even if they had done something to stop him, that's not a bar. So it's simply the fact that they attend. He thinks himself, understandably, that the professionals will take over. He leaves. Your analysis demanded some form of causative involvement to make him leave. That was based on OLL, and that's now gone. So all you do is you just ask yourself the question by reference to the counterfactual, have matters been made worse?
No, that's not right. Is it reasonably foreseeable that matters have been made worse?
Well, no, that's at a later stage.
No, it isn't. That's the initial stage of whether there's a duty.
No,
that's the whole point of the distinction that the Supreme Court made between the question I asked and the question which they said was the prior and essential question.
No, with respect, no.
Okay.
What the first stage is, have matters been made worse? Answer, yes, they've been made worse because the meeting was, they should have told him about the meeting. They told him about, I'm talking about Mitchell now. They kept him informed before, they didn't keep him informed of that. By having the meeting and not telling him, compared to what would have happened if he hadn't had the meeting, things have been made worse. They've increased the danger. Matters have been made worse. But there's not yet liability. There's only liability when, insofar, and this is your point, or the point you've just made, that they realised that, in fact, in Mr. Kendall's case, that he was a rescuer. The point in Mitchell would be, well, did they realise by having the meeting, the risk of what Drummond might do, the risk of attack, that is the foreseeable part of it. Here, and this is why I was taking you in some detail through what the call handler, Mr. Thompson, knew all about the risk, knew about everything. So when he gets that information, he must foresee that if he doesn't pass on the warning, there's going to be the risk of physical assault. So, I mean, there we have it. I mean, I've got a fair bit else to cover, so that probably, well, that may not satisfy your lordship, but that's what I say works on a careful reading of Tyndall. But then, if one looks at Rush, Supplemental Authorities, 557, again relied on by Mr. Justice Ritchie. I don't know whether you have it on paper as well, but it starts at 557, 559 on the screen, and on the facts at 558, you see them set out. It's the famous case about the Omar bombing. And paragraph 5 through to 7 give you all of the facts. I won't go through them, but it's simply they had the opportunity to provide the warning. They didn't pass it on in time. Now, it was only a strikeout. It was a difficult argument because, of course, it's a threat to the general public. So it's completely different to it's a much, much more difficult case than what we're arguing for here, which is a threat to a single individual. If you look at the legal analysis, it starts at 562 on paper, 564 on the screen. And I would ask you to look at this in due course. The core principle in Hill is set out, again, reference to the Lord Phillips at 97, setting out the core principle, dealing with what's outside the core principle. 564, 566 on the screen, paragraph 21. Clark and Linsell, there's a more up-to-date version now, but having traced the path of the authorities, post-Hill states, leaving aside questions where there is an assumption of responsibility, such exceptional cases have not so far been recognised, and their existence might appear somewhat less likely, given not only the outcome, but certain remarks by the majority in Smith, and then 22 in Brooks' case, involving a duty to give appropriate protection to witnesses and alleged victims of crime. Lord Steyn dealt with exceptions to Hill and then set out the what we've already looked at more than once in paragraph 34, and Lord Nichols then paragraph 6, as I've already quoted by this judge, at paragraph 23. I find in the most recent leading authority on this matter, namely Smith, a similar bold assertion of the principle in Hill, accompanied by broad unspecified references to potential exceptions. And then again, the relevant sections are set out at 566. I don't think I took you to Lord Carswell at 109. He was a little more doubtful. I should accordingly prefer to leave the ambit of such exceptions undefined at present. You see that, and on my page, somebody's put in bold with it. So, it's to be worked out in the future. And then Lord Brown again at 135, and the conclusions are 32. I'm satisfied that the category of cases which constitute exceptions to the core principle is far from closed. I'm conscious of the cautionary notes struck in Longro's case, and that's it. And then again, if I just ask you to sideline 34 and 35. So that's what we get from Rush. I haven't got time to go to the other cases he relied on, but you have them in the judgment. And then could I just spend a few minutes just taking you to the relevant parts of Couch on control, and that's supplementary bundle of authorities 1251. And this, of course, is the case that Lord Toulson was so interested in developing the control. He wasn't referring to Tavares at that stage, but the control exception. And could I give you, please, the references in my written argument? Paragraph 55 to 69, our skeleton core bundle 242 to 247. And the written argument on status is 70 to 79 of our skeleton. Core bundle 247 to 250. Let me just pull that up. If one looks at 1292 on the screen, 1290 paper, you see that.
Sorry, which?
This is supplementary authorities bundle.
Yep, page.
Mine is 1290, so I
Thank you.
think yours is 1292.
background?
Yeah. That starts with the judgment that Lord Tilson was more attracted to than the slightly more permissive, wider test that was put by the minority, which includes, this is the New Zealand Supreme Court, so again an apex court. And the relevant parts start at 80. So could I ask you in due course to read through 80 right through to 96. Obviously, I haven't got time to look through all of that now. Excuse me. What they were finding was that it was exceptional to find a duty, but where there are special relations, it's special relations which are the source of the duty. And that's the reference to Smith and Lur's famous reference at 1296 on the screen to what Justice Dixon said. That's the basis of the omissions principle. But then, 83, sometimes the nature of the breach can be relevant to the scope of the duty. For example, in circumstances of the present kind, it may be appropriate to hold that in the case of a failure to warn, the duty is owed more widely than in the case of a failure to control. Indeed, it's possible to posit a case in which a duty to warn might be owed to a substantial number of people. And perhaps, though it would be rare, even to the public in general, that would be a case of rush, albeit difficult causation, issues might then arise. However, in this particular case, this isn't so. This is a case where the Department of Corrections, the probation service, placed somebody with a dangerous background in a particular position, employment-wise, but didn't tell the employees. And then there's some kind of criminal assault. And the argument related to whether or not the relationship between the defendant and the third party and the defendant and the claimant was enough to establish a duty of care by reference to control lacking physical control, but where there was sufficient power and ability to eliminate or at least reduce the risk. And I get that from 1298, paragraph 85. So what was happening here was that there was an examination of the relationship between the Department of Corrections and the perpetrator. And I say there's a sufficient relationship in our case between the police, with all the coercive powers available to them, and RG. There is a sufficient relationship of proximity and closeness, special relations, between the police and Mrs. Woodcock, for all the reasons I have sought to articulate. And we come within, I say, and that you should think very, obviously in my submission, there is room here to incorporate the couch approach into the as yet empty control box. What Lord Burroughs was suggesting an argument in Tyndall was, well, there's no talking about interference. Well, yeah, all right. It's academically, it's been flirted with in other jurisdictions, and even in other jurisdictions, you might say it's established, but there's not yet a case in the courts of England and Wales or the courts of Scotland. And apart from, we got in the end to Kent and Griffiths, which was a sufficient example, albeit not the way in which the case was decided, because that was an assumption of responsibility case, but could also have fitted into interference. And we then jump to the Supreme Court deciding, well, yes, you don't have control in our case, in Tyndall, because we didn't argue risk. We didn't argue the couch point. In paragraph 92 of the written case, if there's any dispute about it, we can produce. But we've specifically said we're not arguing risk, perhaps we should have done, but we didn't. We're arguing physical control, because you were in physical control of the road. And we say rather, well, I can't criticise the Supreme Court, but the Supreme Court decided that he wasn't in control, or the police rather weren't in control of the scene, because it was a different scene. They were in control of a part of the road, but the dangerous part was the ice. So that is that's what I take from Couch. So paragraph 85 is the more specific and obvious the risk.
Is this paragraph 85 of your skeleton?
Paragraph 85 of Couch at 1296. I was just looking at the clock. The more specific and obvious the risk, the stronger will be the case for holding that the defendant, having sufficient power and ability to eliminate or at least reduce the risk, has a duty of care to the plaintiff, fulfilment of which required the reasonable exercise of that power and ability. There is need for both qualifying relationships, control and proximity, not only in cases which require the defendant to control the wrongdoer, but also in cases which require the defendant to give a warning to the plaintiff. And then there's another useful reference to what was said in the Modbury case at paragraph 103. 103 at page 1303, and also a review of the of Dorset Yacht and a few of the other major cases. So that's what I say on control, and control works for us because, or works for Mrs. Woodcock, because there was a very significant risk. Thompson was aware of it. Thompson foresaw what might happen, but he did not pass it on. In not passing it on, there was foreseeable risk of physical harm. It doesn't matter that he was only the operator, and that's a point that was made in the judgment appealed, because one looks at the police service here generally. The Chief Constable is responsible for the manner in which these protective services are provided. So that's control. Status, I have, I think, covered already.
Well, it's unarguable since Tyndall, isn't it?
Well, it's unarguable in relation to standing alone. But what it does do is if we are close to one of the other exceptions, then you can take into account the specific role of the state.
Do you have authority for that
Well,
proposition?
two near misses equal a hit.
I'm sorry?
Two near misses equal a hit. That seems to mean.
All right. Okay.
Which just isn't right, is it?
So
it's one thing to say that if you get through on another route, you can pray in aid status.
that's what I'm saying.
Well, it's not what you said with respect. You said something different.
Well,
You said it to my lord because you've been addressing him almost exclusively all day.
I'm sorry.
But you did say something different.
Well, what I am relying on, sorry, no disrespect to you or Lord Justice Baker at all, but the point I'm making, and if I did misspeak, then I obviously withdraw that. But the point I'm making is the point that the judges made themselves at 87, page 522. It appears, however, to recognise correctly that if, as we have concluded, no other principle supports the existence of a duty of care in this case, the status of the police cannot do so. So, if another principle is in play, I pray in aid status. And then,
So,
with,
that's fine.
sorry, forgive me.
No, my mistake.
And then, in relation to just finishing off on interference, now, just allow me to go through this, but it may well be that I've covered this sufficiently. Mr. Warnock's one of his main points on why I can't rely on paragraph 56 of Tyndall. Let me just get that up again. And this is the question, the factual question on the lack of reasonable foreseeability, the fact that the police did not know that Mr. Kendall was a rescuer. They thought that he was simply a man seeking aid to get to hospital. Equally, a similar point is made here by Mr. Warnock, that the call handler can't have known that there was, or lacked that element of foreseeability in relation to the role of the neighbour. He said that the neighbour gave no evidence. If there's any criticism, and that is, I say that is sufficiently met by the existence of the transcripts. That's all that's there. As I've said, you can infer from that. If a point is made on pleading, well, the principle has only been in play since the 23rd of October 2024. So this is a respondent's notice point. So 5 days or so on, Mr. Davey can be forgiven for not having developed it fully at trial. Enough is pleaded, even though it's pleaded as a breach, not as duty. We have enough in the transcript. The words of the call handler are sufficient. In looking and me adding in making matters worse as an argument, we are looking at the transaction as a whole. That's Tyndall, paragraph 45 and 48. And but for what the call handler said in terms of what I have called the assurance or the representation, the conduct, that is what made the neighbour step back. And when I got too excited and was too dramatic, at that stage when she could have done something and it would have had a causative impact, in that there was enough time between the exit of the house and the attack a minute or so later, then that is enough. Reasonable foreseeability established, dealt with the knowledge of the call handler. Yeah, he knew of the death threats. Mr. Warnock can't begin, I say, to suggest that there was no understanding on behalf of the operator that in the absence of passing on the warning there would be an unfortunate outcome. And that's really how I deal with it. I mean, I think there was a question that yesterday from my Lord Justice Holroyde in relation to the reference to the police keeping it secret. I mean, I'm not suggesting at all that it was deliberately. What he wasn't doing was seeking to turn. It was not a positive. You don't look on the whole of Mr. Justice Ritchie's analysis as a positive act, ignoring the omissions principle because of that unfortunate use of language. So I say very much, despite that one word, it was still a proper analysis which is defendable on ordinary conventional assumption of responsibility lines, insofar as you accept all of the submissions that I have made in relation to how one can get around Michael and distinguish it on the facts. So unless there's anything else, my lords, those are my submissions.
No, thank you very much. Yes, Mr. Daly.
Thank you, my lord. My learned friends, I just want to deal with one or two quick matters before I deal with causation. My learned friends taking you to various judgments in Brooke and Van Cole in relation to the exceptions. I would like to take you to one more. It is a dissenting judgment, but in my submission it's important. And it's at...
I'm sorry. My understanding was that topics had been divided between counsel.
Yes.
Not two goes at a particular topic.
I just said, Mr. Daly, you could make two quick points. I mean, I think it's a very, very rapid point.
Well, that may be so, but I'm afraid it's not in your gift, Mr. Bowen. The work was divided up. The court has proceeded on that basis. I'm sorry, Mr. Daly. But deal with the topic you told you to deal with.
Dealing with causation. I've had communications with Mr. Holcroft. You're both trial counsel for our respective clients at the trial. It was a 5-day trial listed in person. And on day one, unfortunately, I found that I had symptoms of COVID and was concerned that it might be COVID. And the trial was therefore changed to remote hearing. The evidence finished on the Friday. We gave written submissions on the Monday. Now, my lords, you'll see from the close of the claimant's evidence, and I won't ask you to look at it, but the reference is Supplementary Bundle 262, that His Honour Judge Murdoch asked questions after the claimant's evidence. He didn't raise the question of what she would have done if the police had arrived at that point. We then provided the written submissions for the Monday morning. There was absolutely no mention in my learned friend's outline submissions on closing of anything to do with the claimant not giving evidence on this issue. He did refer to other issues on causation, but that was not one. Now, I have to say I don't remember His Honour Judge Murdoch raising the question of this precise question of causation, because the obvious thing for me to have done would have been to have asked for the claimant to be recalled. The first, and so I've got no recollection of that. The judgment was emailed to the parties to counsel 2 months later on the 9th of March 2021. And you'll see from Core Bundle 158, His Honour Judge Murdoch stated the claimant had advanced no evidence if she had been aware that he was outside, that she would not have left the house. The learned judge did not suggest in his judgment that he'd raised this issue during the trial. There was then an application for permission to appeal before His Honour Judge Murdoch, and that was heard on the 9th of August 2021, so some 7 months after the trial. I served my skeleton argument in support of that application on the 20th of July, and in relation to causation, I relied on most of the points set out in the respondent's skeleton argument at Supplementary Bundle 254, so almost identical to the ones before you in support of the respondent's position on causation. The first assertion that I can find in my records that the learned judge had raised this issue was in my learned friend's outline submissions for the application for permission to appeal, and those submissions were dated the 3rd of August 2021. On the 8th of August, on the 9th of August 2021, the morning of the application for permission to appeal, which was listed for 2 o'clock, I sent an email to His Honour Judge Murdoch, and this is agreed between the parties, and I drew his attention to the list of factual and legal issues, which is a Supplementary Bundle 211.
SB 211?
211.
Thank you.
213 electronic. Now you'll see at paragraph 4, well, first of all, we deal with the question of the schedule of Scott schedule. But then at paragraph 4, as to the legal issues, the trial is to be on liability only, and the issues are limited to: did the defendant owe the claimant a duty of care? Did the defendant breach that duty? Did the claimant contribute to the attack on her by her own negligent conduct? Now, at trial, my learned friend abandoned any allegations of contribution.
I'm very sorry, but I'm just sorry. A little bit of a technical issue. 211.
211.
Okay, I'm finally there.
The paragraph 4.
List of issues, paragraph 4.
And the issues are limited to: did the defendant owe the claimant a duty of care? Did the defendant breach that duty? Did the claimant contribute to the attack on her by her own negligent conduct? Now, the allegations of contributory negligence were abandoned at trial. It is correct that there was nothing in the witness statement in relation to what she would have done. The witness statement was prepared. Bear with me a second. The witness statement was prepared after this list of factual issues was agreed. This list of factual issues was agreed for the pre-trial review.
I'm sorry, Mr. Daly, I must have missed a step in the argument. You've been drawing our attention at paragraph 4 of this document to the list of legal issues.
Yes.
Where's the list of factual issues?
Well, we didn't reach agreement recorded on this document in relation to the list of factual issues. But if I can say this, at the case management conference, directions had been proposed by the defendant to deal with breach, duty of care and breach. And that was then adopted by, well, the claimant solicitors agreed those directions, and they were accepted by His Honour Judge Hedrick. Now, I have to say, I don't know when I came to look over the witness statement, because it was passed to me by those instructing me. I can't remember what was in my mind in terms of anything to do with what she would have done. But I would say this, that it wasn't raised in my learned friend's submissions at closing.
Do we have the parties' skeletons for trial?
I do, yes.
Do we?
You don't, but we can make them available. I can't say anything further in relation to what happened at trial, other than that my recollection, I don't recall it being raised by His Honour Judge Murdoch. But clearly there was no evidence given by her on that issue, and there was no cross-examination. I want just to respond next to some points that my learned friend Mr. Holcroft made. And that was in relation to, first of all, in relation to responding to the call. And I'd like to take you to supplementary bundle, page 150.
150.
Yes.
Thank you.
You probably best start at 147. It's the witness statement of Gary Marriott. Gary Marriott was a person who the claimant had spoken to on at least a couple of occasions on the telephone when she telephoned the police. He was also the person to whom Mr. James Thompson passed the call. So both Thompson and Marriott were involved in the neighbour's call, responding to the neighbour's call. And the paragraph I'd like to take you to is paragraph 15 on page 150. And that is that P.S. Randall self-deployed, i.e. he called up and advised me he was going to the incident. So it's not just a question of the operators not making the call to the claimant or P.S. Randall making the call to the claimant. He had the option of telling the operators. He was the police sergeant. He speaks to the operator, clearly, spoke to Mr. Marriott, but didn't tell him to ring the claimant. My learned friend Mr. Holcroft made the point that most offenders do not want spectators, so attacks in the light of day are unusual. Well, that may be true, but the police knew that it wasn't true of this offender because he had been convicted of headbutting the claimant's husband in February 2014, if my memory serves me correctly, and that was recorded on the CCTV. So Mr. Guzzleyurt knew full well that there was CCTV that was focused on the front of the property, that would record him arriving. He'd also gone to the claimant's work. He was undeterred. He was not someone who was worried about daylight or being seen. My learned friend also said, well, no one knew that he had a knife. Well, if I could ask you to turn to SB Supplementary Bundle 186. This is, I don't know whether all your lordships are there. This is the report compiled immediately following the call from the neighbour, and it records two things of particular importance. That the child protection team were aware of Guzzleyurt, and that he may possess firearms.
What was the last thing you said?
That he may possess firearms. It's the last, you see that paragraph at the top of the page, the message text, the last two words, three words, may possess firearms.
What is the meaning of the words which precede that?
Do not use warning.
Not use warning.
I don't know, but my point is this, that it doesn't really lie in the defendant's mouth to say, appellant's mouth to say, well, we didn't know he had a knife, or no one would know he had a knife. They clearly and already knew this man was dangerous. Mr. Holcroft then next took you to the policies and talked about informing victims within 5 days and so on. But I'd like to take you to Supplementary Bundle 163. My learned leader took you to this earlier, but I want to draw your attention to one particular point. And it's the section under keeping the victim informed, 3.7.1. Mm-hmm. And in the second half of that paragraph, beginning Office for Criminal Justice Reform, This may include informing the victims of facts that come to the attention of the police, which may later affect the risk assessment and the action taken. The contact with the victim, this contact with the victim, may prompt further information from the victim and assist them to take steps to improve their safety. Now, that is a document produced by the Association of Chief Police Officers. You'll see in the bottom right-hand corner. It dates from 2009. And it's from the Practice Advice on Investigating Stalking and Harassment. It is right to say that the appellant called Inspector Tompkins, who said that this advice was not current at 2015. But in my submission, that doesn't really assist the defendant.
Was that evidence accepted by Judge Murdoch?
That it was no longer current. I think it was. There was no challenge to that. But my point was the principle remains the same. And one wouldn't have expected a lesser demanding guidance to replace this one. My learner friend then took me to supplementary bundle 89. And in particular, the telephone call, track 11. His point was, well, she didn't answer then. Why would she answer if they'd made an emergency call? Because this was, of course, before the neighbour's call. Well, we don't know what time that call was made. We do know that it had to have been made after the respondent's call at 12:18 a.m. So 18 minutes past midnight on the 19th of March is when she made her call. And we know that it was before the neighbour's call at 7:32 in the morning. The timings of these weren't provided by the appellant. They don't appear to have been provided to the IPCC either. This issue wasn't raised at trial. For all we know, it could have been the operators calling the claimant about some information immediately after the end of the previous call. We just don't know. We do have, of course, witness statements from Marriott and Thompson, who were two of the people receiving calls and who might have made this call, but their witness statements were silent on it. I didn't cross-examine on that basis. At trial, as far as I can recall, I don't think this point was brought up about this call. I don't think it was brought up before Mr. Justice Ritchie either. Mr. Justice Ritchie was tempted to draw inferences, and he would have been considering in my submission the same points that we have raised in our skeleton argument. Bear with me. which is at 4 bundle 255. Hard copy 254, electronic copy 256. And in my submission, His Honour Judge Murdoch should have drawn inferences, as should Mr. Justice Ritchie, from facts which were known. His Honour Judge Murdoch made it very clear that he thought the claimant was an honest witness. He also made it clear that by 6th of February 2015 and throughout February and in March, and the lead up to this neighbour's call and this attack, she was different. She wasn't going back to RG. She was supporting a prosecution, although she had worries, as my own friend, my own leader took you through. But she was scared, and that much is abundantly clear from the transcripts. Her whole case was predicated on her not going outside. Her particulars of claim attributed her injuries to the appellant's failures, the failure to warn her. My learned leader took you to the transcripts, but just looking at the skeleton argument, para 93, on which I rely, on the 18th of March, she had asked officers to attend her work, as she was too frightened to go home because of the possibility of finding RG there. She thought she was safer for the moment, children at school, to stay where she was. Number 5, on the previous evening of the 18th of March, RG had attended her home. She did not speak to him. She did not go out to confront him. She did not open the window to speak to him. No evidence to suggest that that sort of conduct took place. She told the caller she was too afraid to look out of the window. His Honour Judge Murdoch made it clear that the claimant, he found that the claimant had asked for protection. When the officers went round in the early hours of the 19th of March, she wanted someone to stay outside. In her witness statement, which is at supplementary bundle 131. In the morning, I got the children ready for school as normal. Because of what had happened the day before, I was going to drive them to school myself. I'd just like to pause there for a second. The fact that she had her children with her meant not only was there a risk to the children, but she was at more risk. Because a parent who's trying to look after children during an attack puts themselves in greater risk, inevitably. The police car had not returned, but everything looked normal when I looked out of my bedroom window as I was getting ready and just before I left the house. My ex-husband had stayed at the house, and I asked him to leave the house at the same time as me, as I was anxious. there is another point in relation to her witness evidence, which I would like to draw to your attention while I'm discussing her evidence, and that is the statement she made to the IPCC at page 120, supplementary bundle, page 120.
Was this before the judge?
Yes, it was.
Okay.
And it's just the top two lines. Next morning at 7 o'clock, we got up early and got ready. I had no phone calls from that morning from the police.
But that's not right, is it? Because there was the unanswered call.
Well, we don't know when that was.
Well, we do. We know that it was after, I think you said, midnight.
Yes.
And it was before 7 a.m.
Yes.
So it's sometime that morning. I had no phone calls that morning from the police.
Well,
there was a message on her phone saying this is an urgent message.
There was, but we don't even know that that wasn't received whilst the police were there. In which case, why would she bother answering it? They were there for quite a long time. There was a manhunt, there was a dog. They were there for a couple of hours.
Overnight? Overnight?
Yes. Yes, from 20 past midnight, whenever they arrived after the call. They were there for quite some time, at least 1:30 in the morning. It might have been longer, but they were there for some time. And the timing of that, or the information in relation to the timing of that phone call, is certainly in the appellant's hands, or was. Thank you. From behind me, my attention is drawn to the fact we don't even know they called the right number.
We don't even know.
They called the right number. All we know is that
presumably you checked that these were all calls to the same number, so that either they were all right or they were all wrong.
No such investigation was carried out by either side.
Right.
And then number 8 on call bundle 256, the respondent's husband stated in his witness statement that she tried to return to the front door but was unable to do so. She's not someone who's going to challenge this man. She's already too afraid. And my submission, the evidence, leaving aside the fact she didn't give oral evidence on this point, the evidence is compelling as to what she would have done. And it's not as if an adverse inference can be drawn from the fact that she didn't give oral evidence. Clearly, in my submission, it was a matter that certainly wasn't on my mind, and she wasn't cross-examined on it. And as I've said, this point wasn't raised in my no defence closing submissions.
Could you just give us the reference to her husband's statement? I don't think we need to go there, but...
Yes. It's supplementary bundle 145 electronically, 143. And he says, I immediately turned back and ran towards the house to get the kids and Essingall to get either back into the house or into the car. Unfortunately, they could not get to the door quick enough as Mr. Gozzleyurt went straight towards Essingall and started to stab her. So his evidence was that she was going towards the door. Now, I accept that the amended defence put in causation as an issue, but it certainly wasn't flagged up as something that she wouldn't have done. My submission, had she given all evidence, I would have been able to rely in support of her evidence of all these inferences But in my submission, those inferences alone, if you can't draw an adverse inference for her failure to give evidence, are sufficient for His Honour Judge Murdoch to find that she would have stayed in the house. I ask you to pose the question, well, what would have happened if the claimant had died in the attack? She wouldn't have been able to give oral evidence, and all we would have had were the inferences. And I ask yourself to ask this question, given the evidence that was available, what is the realistic chance of the defendant, the appellant, having persuaded a judge that notwithstanding all that, she would have done what no sane person would have done?
Well, all your features 1 to 9 would still have been before the court.
They
if
were.
She had died.
Yes, they would have been still before the court. She died. But
I'm not sure your submission adds anything. I mean, if your submission, which you've made very clearly, is good on 1 to 9.
Yes.
It's good. Thank God she survived, but it would have been. It's not added to by what the position would have been if she had not survived.
I'm sorry, I didn't quite catch that.
I don't think. I'm just questioning whether your last submission,
yes,
what would have happened if she had not survived, actually adds anything, because points 1 to 9 would still have been available to you, and the inference would have been just as strong or not strong.
Well, my point is her claim would have succeeded.
Well, I know that's your point.
on causation. Now, if it would have conceded, had she not been available to give evidence, had she died, then if you don't draw an adverse inference from her failure to address that issue, and she wasn't cross-examined on it, and she wasn't asked a question by the judge, in my submission, she should succeed just as her estate would have done had she died.
Yeah. And we obviously we have your submission that it just wasn't an issue.
Yes. There are circumstances in my submission where it's not unusual for evidence of causation to be missing. Take the scenario, for example, of a doctor who fails to treat a patient, fails to attend to their house after they've been called, and is negligent. Does anyone ask the patient, well, would you have consented to treatment had the doctor arrived? Because one accepts that a vulnerable patient in those circumstances would do what most of us would do, which was to accept the treatment.
Well, if it's an issue, then competent lawyers acting on their behalf would expect to put in evidence that clobbers causation.
Yes. Well, had that been raised as a specific issue as, in the defence...
You like to think you would have acted competently.
I absolutely would have responded
exactly.
to the...
And I'm not questioning that. I'm just again, maybe I'm being too picky.
In my submission, if the defendant really wanted to run that argument, they should have made it explicit in the defence. I also prelude the overriding objective. The whole purpose of litigation is to obtain a just result. Now, one can't help thinking, at least for myself, that His Honour Judge Murdoch may well have made the decision fairly early on, when I say early on, before his written judgment, or during the course of the evidence, that he was not likely to find for the claimant on duty of care and breach. If that was the case, that would explain why causation is not dealt with in any detail in his judgment. But if he had thought that he was likely to find or there was a good chance of him finding, for the claimant on breach of duty of care and breach, for the judge not to have asked that question, in my submission, is surprising, to say the least. This isn't a game. The purpose is to strive to obtain justice. And in my submission, if His Honour Judge Murdoch was going to find against the claimant only on causation, it would be extraordinary for him not to have asked that question. Where it appears that both counsel have not raised it. There are some authorities on the question of causation. I think that we've I think my Lord Justice Stuart-Smith referred to Capital as one of those cases where there was a reference to causation on making matters worse, where the burden in effect passed to the tortfeasor. There is comment also in the Supreme Court, which is the decision of the Supreme Court in Tyndall, and that is at page 509 of the electronic bundle, and it's paragraph 33. And I think it's the same point that arose in Capital. It's making matters worse where the burden shifts to the defendant. There's also a Canadian authority which I'd like to draw your attention to, which is at the Supplementary Authorities Bundle 1211.
1211?
Yes. I beg your pardon. It's at page electronic bundle 1222. I'm sorry, it's 1225. Heading causation.
Issue 3 are we talking about?
No, it's at 1225. Heading causation above issue 2.
At the top of the page.
Yes, thank you. And it's the last paragraph in that half page, beginning where the negligent conduct. Where the negligent conduct alleged is the failure to take reasonable care to guard against the very happening which was foreseeable. The claim should not be dismissed for want of causal connection. I'm conscious of the time. I'm going to refer to two authorities, but I will simply give you the page references, if I may. One is the case of Stapley versus Gypsum, which is at Supplementary Authorities Bundle 1569, 1571 for the electronic bundle. And it's the 2 or 3 lines halfway down the page. It's very short. A jury would not have profited by direction couched in the language of logicians and expounding theories of causation with or without the aid of Latin maxims.
I'm very sorry, which page are you on?
1569 of the hard copy, 1571 of the electronic.
Is this the new supplementary?
Oh, it is. Yes, it is.
Yeah.
Great.
1569.
Yes. 1571 of the electronic.
Okay. That's what I'm missing. But the bundle page is 1569.
Yes.
And you're where?
Halfway down the page, almost exactly half. The jury would not have profited. The jury would not have profited by a direction couched in the language of logicians and expounding theories of causation with or without the aid of Latin maxims. The question, which is the question of causation, must be determined by applying common sense to the facts of each particular case. And in my submission, applying common sense to the facts of this case, the claimant would not have gone out to challenge Mr. Guzzlewood. The last authority is the case of Vale, which is at 1577, 1579 of the electronic bundle. It's a section on causation, at paragraph 29, 1586 of the electronic bundle.
There's some highlighting. Is that?
They're the relevant passages. Perhaps I can take you straight to the quote from Drake versus Harbour.
Where are we?
So that's paragraph 32. There are other highlighted parts which I would invite you to consider when you retire, but just for the moment, the decision in Drake versus Harbour, Toulson LJ, was approved, where a claimant proves both the defendant was negligent and that loss ensued, which was of a kind likely to have resulted from such negligence. This will ordinarily be enough to enable a court to infer that it was probably so caused, even if the claimant is unable to prove positively the precise mechanism. Now, I accept that the claimant, in this case, could have given evidence as to that missing piece of evidence, but in my submission, the absence of it is not fatal for the reasons I've already outlined. My Lords, unless there are any particular issues, those are my submissions.
Anything else? No, thank you very much. Yes.
Just on causation, if the facts had been that the neighbour had phoned up the police and said, I'm going to give a warning to Miss Essingo, and the police had said, no, don't worry, we'll do that for you, we'll pass on a warning, leave it to us. And if then the police hadn't done what they'd said, and the police had said, well, a warning wouldn't make any difference anyway,
then there are two aspects to causation which still need to be considered. This touches on the capitals and counties point. The first is if the police are saying, well, a warning wouldn't have made a difference because either the neighbour wouldn't have made it in time, or she'd have tripped on the way, or something would have happened to make that not happen, then one can see that that's an issue in the capital and counties area of causation. But it's a different matter what the claimant herself would have done.
If warned.
If warned. As to whether causation was an issue, I'm just going to give you, it was put in issue in the defence. It's paragraph 37 of the defence, causation was an issue. We can, I'm sure, the Mother Juniors can sort out supplying the opening and closing arguments that were written at trial. They're called outline submissions on behalf of the defendants. But what the defendant's submissions on causation had said, both in the opening and the closing, was that the defendant considers that none of the alleged failures can even arguably be said to be causative of the vicious and serious attack of the third party. So it clearly, how it was developed orally.
I think we should see them.
Yes, how it was developed orally, clearly I can't help with, and we don't have a transcript. But it would be wrong to say that causation wasn't an issue before the judge.
Thank you.
Unless there's any other point I can help you with. Those are the only points of reply I had.
No, thank you very much. Right. Right, timetable for the rest of the case then, please. Mr. Bowen, back to you, I think.
Yes.
The remainder of the case is the claimant's appeal.
What time are you sitting to this evening now? 'Cause what I intend to do either now or very quickly tomorrow, depending on your level of pre-reading in CJPJ, is open it. But I don't want. I'm assuming you don't want a long opening. You've read the judgment. You've read the grounds of appeal. All I was intending to do, but only if it helps, is just take you to where most of the material is. I was going to read through the findings of the disciplinary panel and the main findings of fact, and then hand over to Mr. Chapman. But if you're acquainted with all of that material, I can just hand over to Mr. Chapman.
Right.
Speaking entirely for myself, in outline, yes, but if it's in your skeleton,
everything's in the skeleton.
But if it's in the skeleton, it need not be repeated except
let me
the
just
stuff
check
that
that.
they particularly want us to have in mind. Yeah.
I mean, I think all of the major material, yes, of course, is in the skeleton, and it's all in the judgment.
All right. Well, I mean, we don't want to stop you if you want to just work from your skeleton and just draw attention to anything in particular you want to mention.
Well, I wasn't going to do that, my lords. The skeleton you'll find at 25 to 26 of the core bundle.
Yes.
Let me just rip through it very quickly, because if you're only sitting till 3:30 tomorrow, it's a race against time. But the trial was 4th to the 10th of May.
I don't think that's a fair way of putting it at all, I'm afraid.
Well,
I really don't, Mr. Bowen.
Oh, I'm sorry. No, I'm just trying to. I don't want to deal with anything unnecessary.
Right.
I mean, that's all I'm saying.
All right.
So the skeleton you'll find. Judgment was given on the 1st of July 2022. The judgment you find at core 78 to 129, where our case was dismissed on the basis it was all a failure to confer a benefit, and these were a series of permissions. Permission was granted on the 1st of January 2022 by Lord Justice William Davis, linked to Woodcock. And you see that at 207 of the bundle. And I'm hoping there's no difference here between. Well, that must be 207 of the supplementary bundle. sorry, I've something wrong with my reference there. 130. Sorry, of the call.
Yes.
And you'll see there that he felt there were links between both cases, and it was a matter of significant public interest. Our skeleton 25 to 46, the police skeleton 47 to 66 of the call bundle, and you'll see a full chronology. So we don't have the same difficulty in terms of any disputes of fact. And you see that at page 69 of the bundle. The structure of the judgment, the facts are very fully set out between paragraphs 6 and 36. That's core 80 through to 92. You don't need to be troubled by paras 37 to 50. Core 92 to 97, but that's all on limitation. There were permission to amend issues, paragraph 51 to 57, core 97 to 99. And then an important section on the disclosure and barring service section, paragraphs 58 to 62 of the judgment. Now, in terms of the findings of the disciplinary panel, you see that at core 84 to 85, the basic facts I'm not going to open because you're obviously aware of the discovery of the images, the severity of the images as far as the jolting back in the chair that's referred to when the officer attends, the seizing of the computer, the handing over of the computer to the HTCU, the delay of, I think, 14 months or so, and the failure, his initial failures in relation to what's described as the first period. Because there are two periods in this case: the period between the report of the images and the attendance of Sergeant Ellaby, and the receipt of the report, which named NP as I think I can name him, Michael Ponzo, as the downloader of the images, and then the second period between the the identity of the perpetrator and the terrible criminal acts that happened to the second two families. There are three families that are suing here. You've got, as you know, CJPJ, the niece and the nephew of Mr. Ponzo.
Well, he shouldn't be named.
I think he was. He may or may not have been named in the judgment, but I won't name him thereafter. The findings of the panel in relation to that first period and in relation to the second period, you see set out at paragraph 17 of the judgment. If I could just ask you to turn to that at page 84. This is in relation to period 2. DS Ellaby did not in fact progress the investigation at all thereafter. So that's after the perpetrator has been identified. On the 9th of July 2014, he was advised by HTCU that the loaned laptop was due for return, and he in fact returned it on the 5th of September. He did not interview MP at any stage. The disciplinary panel conducted a misconduct hearing on the 31st of July 2017 and made the following findings, which have been admitted by DC Ellaby, and are admitted by the defendant in this claim. And I think the full findings you see just for your note at supplementary bundle, page 51. The panel then considered the period of time spanning the 20th of May 2014 to the 1st of July 2015, that's the second period, during this period, Mr. Ellaby admitted the following. Save for informing the Public Protection Unit that he had received the computer on the 20th of May, he did not inform any other person about the findings of the HTCU. He did not ask for advice from any supervising officer or specialist as to the appropriate course of action he should take. He did nothing actively to advance the investigation and failed to make any record on niche, that's the local intelligence system, as to the material that had been recovered by the HTCU. It's significant that Mr. Ellaby had an understanding of how important it was for the records to be updated. So he kept the findings to himself, he didn't seek advice, he didn't advance the investigation in any way, and he failed to make the record on niche. Now that's very important, because if there had been a record on the system, it would, I think, have then gone on to the Police National Computer, and then when the subsequent applications were made for DBS certificates, part and parcel of the general protective system set up by the state, then he wouldn't have been able to get a clear certificate or represent that he had a clear certificate. And then he wouldn't have been able to work with children, if that's the case. And we have very clear findings on causation from the judge at paragraph 63 of the judgment. He would not then have been able to, certainly he wouldn't have been employed by third family, and we also, we say the same as in relation to the second family. Then just going over the page to 85, the panel did not consider that dishonesty had been proved, but did conclude that on the balance of probabilities, DC Ellaby's behaviour demonstrated a lack of integrity, stating he must have been aware that any competent police officer in his position would either have actively advanced the investigation or, alternatively, have handed it over to somebody more experienced. His failure to do either of these things over a period of 11 months was inconsistent with that which would have been expected of a diligent and competent officer. These failures demonstrated a lack of integrity in that he both failed to act in the right way and failed to do the right thing at any point in the second period. These failings are capable of justifying dismissal and therefore gross misconduct. And then an outcome hearing was held on the 1st of August 2017, at which the disciplinary panel stated, your serious failings, as we have found them to be between the 20th of May 2014 and the 1st of July, i.e. the second period, are difficult to understand. You have in reality offered no satisfactory explanation at any stage of proceedings for failing either to progress the investigation or if, as you profess, a significant degree of scepticism being injected there, that you were too busy to advance it, hand it over to another officer. As a result of your behaviour, you created a risk of harm to the children, obviously important there in terms of the making matters worse and interference principle, because he was retaining the file, stopping a competent officer, properly investigating it at a sufficiently early stage, causatively, to have, and we'll see this in a minute when we look at the judge's findings of fact, then during the first period, had he investigated and taken basic investigative steps after the seizure, but before the identity of the downloader, the judge found that given he was an experienced officer detective, the downloader was a callow 16 or 17-year-old boy, that he would have made admissions, he would have been the main suspect rather than the father who...
So I don't, with respect to the judge, I don't quite understand that paragraph, speaking for myself.
What the fine? I mean, I'll come to those when we look at J63. But if I just continue with the outcome hearing, you rightly pointed out in your interview, you knew that there was a likelihood that you had recorded things that you should have done. Sorry, I'll read that again. You rightly pointed out in your interview, that's with the IPCC, that you knew that there was a likelihood that had you recorded things that you should have done, those in charge of issues of child protection would have potentially had access to information that could have helped them to protect the vulnerable. You have to live with that decision. So what's behind that is that had he, after the identity of MP as the downloader, then there would have been a reference to social services. There would have been a flagging up on niche. So there would have been communication with the family, crucially, that the younger brother was suspected of a completely inappropriate interest in children. And then he wouldn't have had open access and contact to his niece and nephew. So that's CJPJ. The date on the indictment of the very, very could not get more serious sexual offences that he carried out with these children, I think from memory is the 1st of November 2014. 2013. Just sort of forgive me, thank you, 2013. I.e. Way before the HTCU. So there was abuse causatively would not have occurred to CJPJ. And in the second period, when there was the disclosure from OB, which was, you'll remember, looked at initially it came through, I think, a counsellor. Then there was a reference to the police. There was an investigation. That investigation went nowhere because we just had the disclosure from the boy in the bath. Had that been looked at in concert with the fact that the then babysitter, the downloader, was in fact being investigated for the downloading of illicit images, it is inconceivable that he would not have then been arrested. And then there would have been no abuse at all in relation to the later family. And then going back to the panel decision or the tribunal decision, had matters rested there, it's likely that we would have had no option but to dismiss you. We have, however, asked ourselves whether or not the public confidence in the police force would be undermined if you were to remain an officer. We've had the unique opportunity in this case to hear the views of members of the public who are directly affected by your failings. It goes on to say they've shown extraordinary humanity and compassion, and they were not amazingly seeking his dismissal. And then, having said that was the most compelling mitigation of all, he kept his job. Now, it's clear that the disciplinary panel took the most serious possible view of Ellaby's behaviour, and it's our contention that what he did during that first period can properly be described as egregious, and that's a finding the judge should have made, and that has relevance to the, certainly to the Article 3 arguments that you're going to hear from Mr. Chapman. And then if I go to the findings of fact at 102, and then the findings of fact, in my judgment, there can be no doubt that Wiltshire Police, through DS Ellaby, were negligent in relation to their investigation into the indecent images found on the laptop seized by Sergeant Ellaby on the 21st of December. Indeed, by reference to the findings of the disciplinary panel in July-August 2017, this is conceded, but only by reference to those findings. However, in my judgment, the negligence of the defendant went significantly beyond that as found by the panel. These are my findings as to what should have happened and what would probably have followed, and then they're set out. When Sergeant Ellaby had the laptop sent for examination, he should have ascertained after the laptop had been subjected to the initial triage process how long it would probably have been before it could be examined. Had he done so, he would probably have been told that it was likely that it wouldn't be for 12 months. So that's no question about the time scale, 12 months at least. Sergeant Ellaby should then have considered what he could do in the meantime to advance the investigation. The first priority would have been to ascertain who was responsible for the images on the computer. To this end, he should have interviewed those who had access to the computer, starting with BP, that's the father. Had he done so, he would probably have ascertained that BP was unlikely to be responsible for the downloading of the images, and usage of the laptop would probably have led to MP being the prime suspect. Interview or further interview after the others had been interviewed of MP would probably have led to MP admitting that he was responsible. At that time, he was not yet 17, and an experienced officer such as DS Ellaby interviewing a 16-year-old could have been expected to elicit appropriate admissions. DS Ellaby should then have taken advice from a senior officer, or at least an officer experienced in the investigation of indecent images, as to how the investigation should then proceed. Had he done so, he would probably have been advised that little further could be done at that stage so far as prosecution was concerned until the computer had been analysed. But the investigation should be kept open, and importantly, MP should be entered on niche as a nominal. This was the conclusion the IPCC, and it is my conclusion, of the IPCC, and it is my conclusion as well. It's likely that this would have been January or February 2013, so very soon after the initial complaint. Had MP been entered on niche as a nominal, the police would not have informed Network Healthcare Professionals or the Scout Association that it had no relevant information. On the contrary, the information that MP was suspected of being responsible for the downloading of indecent images of children would have meant that the police would have regarded him as a person who was not suitable for work with children. And then the finding in relation to what the family would have been told is at Romans 7. In addition, given MP's age, combined with the suspicion that had fallen on other members of the family, DG would have been informed of MP's admissions. Indeed, it's likely she would have been present at the interview. And the information that MP had admitted being responsible for the images would have found its way to other members of the family, including, importantly, DJ. That's, the mother of the two children. The other members of the family who lived with DG and her husband would have been relieved to be informed that the finger of suspicion no longer pointed towards them. So any opportunity to abuse at that stage disappeared. I accept DJ's evidence as referred to in paragraph 21 above. In my judgment, this was not said purely with the benefit of hindsight, given her own background of having been abused. DJ would not have been happy for her young children to spend unsupervised time with someone who had shown an interest in naked children, even her brother. And MP would have been denied the opportunity to abuse CJ and PJ in the period covered by the indictment from the 1st of November 2013. In addition, it's at Roman 9, as submitted on behalf of the claimants, the identification of MP as a young man with an interest in naked children would probably have led to a referral to social services, and it's to be hoped that his unhealthy interest in young children would have been addressed before it escalated into sexual abuse. MP would not have been able to represent himself as someone with a clean DBS check to the childcare website, to SMASH, that's a youth mentoring service, to the Scout Association, or to NP, that's the mother of the second family, and ED. It is unlikely that he would have been able to work with the Scouts, and he would probably not have applied to work with children in any capacity, as he would have known that he would be found out when the DBS check came back. It's extremely unlikely that MP would have been employed by NP to look after OB, or that ED, that's the mother of the final two children, would have employed him to look after her children, HD and PD. So what we have is the escalation, entirely foreseeable, from the downloading offence to contact offences, which could, of course, have been stopped. Now, the grounds of appeal you see at 24A1 of the bundle. So I could just whip through those very quickly.
Sorry, page?
24A1, on paper at least. I'm not following this electronically.
Yes, thank you.
That's grateful. So the Article 3 grounds are that the learned judge erred in law, reaching the overall conclusion at 119 to 120. Let me just take you to that. So the discussion starts at on 126, paragraph 117 of the judgment. I don't want to tread here on Mr. Chapman's toes, but just to identify the passage. At 119 to 120, we see here that in rejecting Mr. Bowen's submissions and pathway, I'm conscious that because of the parallel decision in negligence, these claimants are left without a remedy except any compensation from the CICA. And in his submission, Article 3 is emptied of its potency and force, despite what was said by the European Court of Human Rights in Z and the UK, in reference to the authority. However, that is not correct. I won't go on. So that's no remedy. And then that's expanded there at paragraph 120. And then paragraph 2 of ground 1, the judge erred in law in rejecting 3 other pathways as relied upon by the plaintiffs, by the claimants, to invoke Article 3 protection, which imposed on the defendant either protective, systemic or operational duties. Now, the operational duty, that's real and immediate risk, the Osmond test, that relates only to the last family, because insofar they would have known of a real and immediate risk when they responded to the disclosure by OB, and then they would have immediately been able to find MP and would have discovered very, very quickly that he was that he was involved in had been involved in downloading, and then he wouldn't have been employed by the final family. And then ground 2, the learned judge erred in failing to find at paragraph 95.8, and that you see at page 117. Were such failures in the overall investigation egregious? I have no doubt that D.S. Ellaby's failures, once he had received the report of HTCU, were egregious. And this was effectively the opinion of the disciplinary panel, which would have dismissed him with immediate effect, but for the generous approach of the families. However, in relation to the period prior to May 2014, in my judgment, the failures which I have identified, although culpable, were not such to be described as egregious. DS Ellaby had not yet received the report from the high-tech crime unit, and his other duties caused him to prioritise those ahead of a further investigation into what may have appeared to him to be relatively minor indecent images. And Mr. Chapman will take you to some of the facts that completely undermine, other parts of the judgment that completely undermine that finding. Furthermore, he appears to have assumed that BP, the father, was most likely to be responsible, and he was already being monitored as a sex offender because of his offences against DJ. But if you look at Core 102, let's go back to 102 at the finding of fact at 63.3. Have that? To this end, he should have interviewed those who had access to the computer, starting with BP. Had he done so, he would probably have ascertained that BP was unlikely to be responsible for the downloading of the images. The usage of the laptop would probably have led MP to being the prime suspect. So two completely...
Yeah, but that's after the computer's been analysed. The previous passage you read understood to relate to whilst the laptop was with the HTCU. May have misunderstood.
Well, I mean, we'll unpick that
Yes.
point tomorrow. So there was so the first failure should have been egregious. I mean, that's just a point along the way, prompted just by a margin note. But certainly from my perspective, arguing the negligence point and the making matters worse issue, it's the retaining of the file and the findings and the evidence that relates to his mindset and why he did it. I concede we didn't plead misfeasance, possibly we should have done. But there was a deliberate, active decision by this officer for self-serving reasons, most significantly the fact that he was more interested seemingly in embellishing his CV, well, not embellishing is the wrong word, improving his CV, because he had never been involved in an images inquiry. On top of that, you have effectively active evasion, positive decisions, not to make entries on the computer, etc. I'm almost there, my lord. So, and then when I've just finished the grounds of appeal, I'll be done.
Yes, thank you.
And then that will give Mr. Chapman a clean run tomorrow. So then, in terms of so that active retention is making matters worse, interfering with somebody else who have done a proper job. Read in all the submissions that we've made so far in relation to Woodcock. So then, under negligence ground 4, given that it was common ground that Ellaby had no understanding of or training in the investigation of child sexual offences, the learned judge erred in failing to include in his factual findings at paragraph 63 of the judgment, for the reference again, page 102, that DS Ellaby should have, and then they're set out, 4 of them: failure to seek advice as soon as he seized it, handed the investigation over to a suitably trained officer who would have carried out a competent investigation, recorded MP as a nominal, the self-serving point at C, yet to handle an images inquiry, evasion of supervision at 5D. Ground 5, the learned judge erred in law and was wrong at 76 to 77. That is 110 of the judgment. To characterise Ellaby's actions as omissions, so applying Tyndall you look at the whole and then ask the question. Ask the question: is it exactly what is it in total, and is it possible then for us to establish in negligence terms a duty of care by reference to the interference principle and/or control? And I won't go. I've just there identified the relevant passages at 76 to 87, but I won't read them out. Ground 6. Alternatively, the learned judge was wrong to find, given the court's findings of fact, between 65(1) and 11, which I read out. That's paragraph 63, core 102, and the acts and omissions, the acts or omissions to act, set out at 66 of the judgment. At 105 to 106, and those were retention, failing to pass it on, closing the case on niche in August 2013 without completing an intelligence report, whereby MP's details as a person of interest or a nominal would then have been transferred to the national database, and his positive decision not to pursue the investigation once he'd received the report. Then the way that it's pleaded is set out in the next 2 sub-paragraphs. And then over the page 25A3, we set out again familiar territory, that those facts fit within one or more of the 4 exceptions.
Are you pursuing D?
We're reading it in the same way.
Sorry?
I'll be reading it in the same way.
Well, you don't need to read it in. I'm just wondering if you're pursuing D.
Well, the answer is yes. And then ground 7. Alternatively, the learned judge should have found that this was a novel claim and analysed the claim in negligence by applying the principles in Caparo, 102 of Lord Toulson, and then the dicta, the approach, at, I think, paragraph 15, talking about the James Bowen case in Darnley. That's Lord Lloyd Jones. Had he done so, he would have concluded that it was fair, just, and reasonable to impose liability on the police in negligence. A failure to investigate would cause the claimant's foreseeable loss and damage. There was the requirement of sufficient proximity between the parties, and that in all the circumstances it was fair, just, and reasonable to impose a duty of care in relation to all 5. My position at trial was that that only ran in relation to the first families, but the judge told me my analysis was wrong, and I then adopt now the judge's analysis that it inures for the benefit of the final 2. Right. I'm sorry it's 20 to 5, but
no, thank
those
you.
are. And I'm sorry, and I do forgive me for irritating you throughout the day.
It's not a matter of irritation. It's just
which I apologise.
Thank you.
But there's been quite a lot of pressure on this side of the bar, as you can imagine.
Yes.
There's a lot to handle here.
We understand.
Yeah.
All right.
So
10:30 tomorrow.
Yep. And Mr. Chapman will begin.
Thank you very much.
All those in favour?